Welcome to Health Law Talk, presented by Chehardy Sherman Williams. Health law broken down through expert discussion, real client issues, and real-life experiences. Breaking barriers to understanding complex healthcare issues is our job.
And good morning, good afternoon, whatever time it is when you're listening to this podcast. Another edition of Health Law Talk here at Chehardy Sherman Williams. Conrad, Meyer on the mic with Rory, Bellina, Chris Martin, rounding out the wealth and depth of healthcare knowledge here at the firm. Gentlemen, good to see you guys.
Good afternoon.
Good afternoon.
It's been a minute since all three of us have been kind of in the studio to talk about some healthcare topics, so I'm glad to see everybody's here. That's good.
It's been a busy time.
To say the least, right? I mean, it's been a busy year, I think, for all of us. To try to find time to come in. And sadly, we've had a lot of important issues that have come up in 2024 that I think have affected clients. So, and I think we got a really big one today, especially in Louisiana, that I think is important. And I think we're going to hit on it pretty hard because I know we've been talking about it for years, and that's non-competes.
Sure. Yep. I think, today's topic is going to be, we'll call it the Louisiana revised non-compete, Senate Bill 165. If anyone wants to go check it at home, it came out of the 2024 regular session. It was co-authored by a handful of Louisiana senators, a lot of big names here, especially in the healthcare world, and it goes into effect January 1st, 2025. So it's given our clients and practices time to understand and digest it, but we're going to kind of walk you through it and talk about the things we like, the things we don't like, the things that we think may be missing, and possible issues we see with it going forward.
Absolutely, Chris. What I know you and Rory both have clients that deal with non-competes. What have been some of the main complaints that you've heard of in terms of non-competes from your clients previously prior to this bill?
Well, from the physician side, I think the main concern is for specialists, for instance, that if say they were doing business with a certain large healthcare system, they'd literally have to move out of the state to carry on their profession if the non-compete was enforced. So it literally, I think, had a dampening effect for certain specialties to come to Louisiana.
And I always thought too, putting aside the aspect of losing that physician, but you're losing that physician's family. You're losing some, one of the statistically top earners from an income standpoint to the state. You're losing their dependents. I mean, we're talking about Louisiana, who already has a declining population, and we have obviously hurricanes with natural disasters, and we have a real issue here with healthcare getting access to the underserved population. So, Louisiana's had so many things going against it, and so many things causing, let's just not even talk about physicians, but just causing people to move away. And then the fact that we have such an expansive allowance of non-competes for physicians here in Louisiana, for these bigger systems to be able to have these in place where, like Chris said, to get outside of the non-compete, they're going to have to leave. So we're losing them, we're losing their spouse, their kids, that income, that tax revenue base, and they're probably not going to come back, right? Why would they come back? And then if they want to move again, they're going to have another non-compete issue to do with. So we're losing that family line forever. So. And
we've watched the evolution of that non-compete over the years. I'm sure you guys have seen it when we get the list of the restricted area or the covered area, or the geographic, whatever the defined term is for the restrictive covenant. And before, I used to see, especially in the greater New Orleans area, I saw Orleans Parish, Jefferson Parish, St. Tammany, sort of the trio, right? Then St. Bernard. And then suddenly it got to the point where it was, going from 5 or 6 parishes to 10 to 15. And I think at one point I saw one with over 30 parishes. And I was like... And
then creeping into Mississippi for some systems.
Right. And I was like, when does this end? Like, that's just nuts, right? Did y'all remember seeing the evolution of that? Absolutely.
The non-compete provision used to be a couple of lines, and then they started listing all the parishes, and it ends up being half a page.
Oh, then they added was non-solicitation, and then you had to do the non-rating clause. In terms of that, I mean, the restrictive covenant just grew like a beanstalk, like in Jack, like it's just magic beans. Let's just make it as big as possible.
Sure. And when you go back to the reason of why did we have non-competes, is it really an issue of your concern that provider is going to take patients and open up a clinic and compete? Is it a penalty? I think a lot of people will answer that question differently on, why were these put in place? And probably in the beginning it was because you were really concerned that if you lost one of your, let's say, a junior pediatrician, that they're going to open up a pediatrician clinic after they've learned everything from you and take populations, and they could open up theoretically right next door to you. But I think we've shifted away from that a lot, and now it seems a lot more of a stick of, we're putting this in there, and yeah, we're investing in you, and we're going to teach you a lot. But I don't think that it matches. I don't think that the penalty of it really matches what the providers are getting anymore. And I could be wrong, but that's just mine.
No, I think it's a stick, absolutely, because now I know we talked about this before, the three of us have, but I'm seeing the stick include not only just the larger geographic area, but then you have the without cause termination extended from 90 to maybe 120 or 150 days or some long period of time, so you're stuck in that job when you do the withdrawal, and then on top of that, the buyout, adding the damage buyout for moving the non-compete. In other words, if you just terminate and you have a buyout if you want to get out of that 1 or 2 year deal, whatever the deal is, and it's a full year salary.
And Chris and I had a common client a while back where the non-compete just didn't make sense, and it came from a practice who just says this is the standard non-compete that we give to everyone. But this non-compete was for a anesthesiologist who typically does not really have a patient per se.
So what's the point of that?
Right. I mean, you're not going to a certain surgery center because you want that person to put you to sleep. You're going there because of the surgeon. So, I really think it's just become this thing, this little monster where we have non-competes, and so many people have signed non-competes, so now everyone gets a non-compete, and it's going to be for all 64 parishes, plus Hancock and Harrison, and creep into Mississippi, and it's the effect of it does not match, I think, what the goal was.
So what, Chris, what is the new law? I mean, what can you walk us through? I know you have some highlights, and I know we talked about this, but where does this now start? I know Rory mentioned January 1st of 2025. What is your take on, if you can tell our listeners who might not be aware of what this is, what does it do now to non-compete starting in 2025?
So if we start with primary care physicians, that's probably the biggest change, is starting in 2025, primary care physicians, which are defined as physicians who predominantly practice general family medicine, general internal medicine, pediatrics, obstetrics, gynecology. Those specialties or those categories of practices cannot have a non-compete that's longer than 3 years. And it's the other important part of it, it's limited to 3 parishes, as I understand it. So the amount of time and the scope of the non-compete have been radically changed.
And
I don't know if it's 3 years. I think it can be 2 years max, but I think after the 3rd year of working.
Oh, that's right.
So where the numbers come, because I had to read this a few times as well. It cannot exceed 3 years from the effective date of the contract. So you go by statute, the rule is that a non-compete can't be longer than 2 years.
That's right.
Right? 23
by statute, 23 right.
2 years. This is now clarifying that if it's for a primary care physician, the overall non-compete cannot be more than 3 years from the effective date. So if you go work for a system and on, let's say today, July 3rd, 2024, you sign a 5-year deal or whatever it is, and they have that 2 year non-compete. Well, once you reach 3 years into it, then it's over. So if you keep re-upping, or let's just say you have a 1-year contract, but you have that 2-year non-compete, if you just keep re-upping, you cannot have a non-compete that goes 3 years after the effective date. So if you sign a contract today, July 3rd, 2024, no matter how many times you re-up, you could work there for 30 years. And typically, that's how most non-competes work right now, is that the non-compete, the clock on the non-compete doesn't start until your last day.
To the termination of the agreement.
Until the termination of the agreement. So
Right.
in my example, if you work there for another 30 years until 2054, then your non-compete goes 2 years past that. This revision says no matter what happens, your non-compete ends July 3rd, 2027. We don't care how long you're there. That's how long it goes. It doesn't end. The clock doesn't start 2 years or 3 years after you're
Does the
gone.
clock start right now, or does it start January 1st?
It's effective January 1st, it is 3 years. It cannot exceed 3 years from the effective date of your initial contract. So I think your question is what happens to everyone
Right
that
now,
has
let's
one
say
in
I
place.
started right now. So, I mean, do I get 8 months credit or 6 months credit but to the January 1st trigger date? I don't, I mean, I'm just, that's something that's not clear, at least to me, it's not clear. But,
like the retroactivity of this statute,
correct,
essentially.
right.
And I don't think it
I think for contracts in existence now, the initial 3 or the 5 year term begins to run on January 1st, 2025.
That's what I thought
Okay.
too, but
And-
I wasn't 100% sure on
Yeah.
that.
So you would probably get the lesser of the two.
Right, so you have to wait until January 1st, 2025 for the start run, the time to start running, right?
makes sense.
Is that, we all agree on
Yes,
that?
Yes.
and the same with the geographic provisions. Those kick in on January 1st.
So there could be a lot of
2025.
contract revisions, I think, on a system level for some of the systems here, and maybe even other the employers to do their revisions on their parishes starting next year.
And as Chris was stating, no more than 2 contiguous parishes.
Right. So in other words, you could do Orleans and Jefferson, but not St. Tammany. Right. I mean, or St. Tammany's
Is
right
that
next to
considered?
Yeah,
For
'cause-
geographic wise, is that considered?
Yeah, because St. Tammany and Jefferson run a line on the lake.
True.
So you can't really do because they touch each other.
So
Okay.
the statute says that the non-compete agreement must specify the parish where the physician's principal practice is located,
That's interesting
and
because
not more than 2 contiguous parishes.
So you read it as 3 totals. That was,
3 total, but the law doesn't really discuss how to define or how to determine what that quote principal location is.
Yeah, because they shuffle them around.
Yeah.
Right.
your principal practice, if you have a clinic in Luling and Metairie, you could, what's your if you share days.
And I haven't looked at that as if there's a defined term for principal practice. So interesting. Now the specialists are different. I mean, I think did they have something, Chris, that addresses the specialist?
Yeah, so the specialist, instead of the non-compete expiring after 3 years, for specialists, it's a 5-year sort of provision.
So
that
what's the
after-
thought behind that?
I think part of the rationale, like you were explaining earlier, Rory, is more time and money and resources are put into specialists, and they're probably more valuable, say, for a health system. So this statute is recognizing that and giving hospital employers a little more time and a little more leeway with respect to neurosurgeons and orthopedic surgeons and
Right.
transplant surgeons. So I think that was probably an accommodation
Right.
in the negotiation.
Makes sense. And I guess you want the shortest period for your primary cares because they're the ones that are probably in most need for a lot of these clinics.
They're also the gatekeepers too. They're the ones. They're the traffic cops where they refer to the specialists.
Mm-hmm.
So you want them to have as much freedom as possible to practice.
Mm-hmm.
Yeah, from a public policy standpoint, to give patients most access.
Yeah, and that's where, that's the patient's introduction usually to the healthcare, field or is that primary care doctor. Hopefully not the emergency room.
Sure.
So that's where they start, primary care physicians. And so policy-wise, you want to give the public freedom of choice and the physician freedom of, decision-making when it comes to where they work, and not handcuff them too much. Plus, we have a shortage of these types, these practitioners, family medicine, internal medicine.
Yeah.
There's a huge shortage.
Totally agree. And I think this is a long time coming. I mean, I think we've heard about this before. A couple of years ago, Rory, we had that attempt that was failed.
Every year there's an attempt that seems to fail.
It seems to fail,
This
right.
one finally made it. I didn't not have confidence that it would make it, but it did.
It did. Well, you know what? And I want to talk to you about that. I think large employers and systems knew this was coming. I think they knew that the leak in the dike had spread and that it was ready to fall forward. And so what I've been seeing is in an effort to sort of lock the dock in, right? Like lock the dock in to the hospital or the system. They've been paying these doctors retention bonuses. Have y'all seen that?
You were mentioning that. I haven't seen it yet, but it's very interesting. Explain that a little more.
So maybe about 3 or 4 years ago, maybe more than that, I started seeing contracts with not only signing bonuses, but then a subsequent addendum called a retention bonus, where they would pay these physicians a lump sum of money with the goal of retaining that physician at the facility or the system, but then having this long pro rata forgiveness period. And a lot of times these doctors would never get counsel to look at this because they thought, oh, it's simply a retention. It's not really a full contract. It's just me getting a bonus. But what they failed to do is when they looked at the forgiveness period, and I think I mentioned this to you, Chris, the one I saw recently was 8 years. So you've got a $200,000 loan that's only going to forgive $25,000 over 8 years. That to me, that's just insane.
It's a form of
indentured servitude.
Yeah. Restraint.
You got it. Yeah.
The other point in this that I'm noticing is, remember, these bonuses or repayment provisions used to say plus. Well, they do say plus interest.
Right.
And for so many years, we didn't really think about interest because it was 2%, 3%.
Sure.
Well, now it's 7, 9, 10, 11%. So it becomes can be a significant component of that repayment obligation.
And that's what I can't stand, guys, because, like, for example, if you've got a client, and I'm curious to hear, Rory, your thoughts on both of y'all on this. If you got a client that wants to separate and they've got the retention bonus and you've got the issue of interest and so forth. Now, I mean, to me, and I'm dealing with this right now with a couple of them, it is almost, that's a hammer. It is an absolute hammer, and they're using this as leverage against the docs. And I really don't think doctors understand when they sign that thing what that really means, because it's free money to them, but it's meant, like we said before, to sort of put the ball in chain.
Yeah, I've always tried to advise physicians that get these bonuses to really save that money until the end of that term and not do anything with it just in case of a repayment, because you don't want to spend money have to take money out that you don't have that you've already spent.
Good luck doing that. Really, I mean,
but it's hard.
Here's $100,000. Just put it away.
Put it away.
Put it in that little
That's always
cookie
my
jar.
advice. That's always been my advice. I don't know if they listen to me, but that's that's what I like. One thing that I thought was interesting in this statute is that the definition of an employer is not defined, and it's pretty vague. And so one thing I was thinking, in a devil's advocate approach is there going to be some sort of movement as to who the employer is, and does that start the clock over? Meaning, if you work for such and such LLC, and then you finish your 3 years, or let's say getting towards the end of your 3 years when they know your non-compete's about to lapse, do they try to re-up you under a different entity or a different organization?
Like assigning it to like a practice group LLC.
Exactly.
Right.
Or what if your hospital or group is purchased and now you're employed by another and you're employed by another company. I mean, I would be concerned that, again, this statute is going to take probably some more revisions to it just to clean these kind of things up. But I saw that in there as, especially with practices being bought all the time, is that, okay, well, now your employer is now such and such private equity, and we're making all these people re-sign, and this clock starts over.
Or do you have the provision in the sale agreements or even in the employment agreements that any assignments, right, will carry the same language and or whoever buys it or changes it will be held accountable to all of the provisions contained in the agreement, something like that.
Yeah, that's an option too. And why?
Very interesting.
And in here, another interesting part that I wanted to get both of y'all's opinion on is that this is not applying to rural hospitals and FQHCs.
I saw that.
And I think that's a reaction to the fact that rural hospitals are struggling.
Yeah.
FQHCs have a unique purpose, and for instance, they have the Federal Torts Act, so you can't sue a FQHC doctor like you normally would under Louisiana law. You have to go through the Federal Torts Act. I think this is a carrot or a benefit to those particular providers, rural health hospitals and FQHCs, to give them a little advantage.
By allowing them to
retain doctors.
By allowing them to have those more strict non-competes.
Yeah, that's my take on it. What'll be interesting to see is, do we see the rise of less employment of physicians and perhaps some hybrid independent contractor arrangement to get around this?
Yeah, because it the language in here, it says any provision in a contract or agreement, but then it says employer. So are people going to get cute with that and say, well, I'm not really your employer, and this really isn't a contract? I think there's the way that it was written. I think they're going to have to come back in and add a ton of definitions, because this is going to become a problem for some practices and systems, and they're going to find ways to work around it.
They better be really careful, meaning practices, hospital systems, whoever decides to try to skirt this with a 1099 or an independent contractor, because you don't want to fall into that, pit where the IRS says you improperly classified this individual. That should be a terrible situation.
And the IRS, my impression is the IRS is stepping up its enforcement of that exact issue of people who are really employees but are being paid under a 1099.
So what do you do, guys, when you have a situation? I mean, I want to get because I know we're going to make this a sort of a quick episode, but what do we tell clients when they are faced with a situation like with this new law? They've got a retention bonus that they've got time left on it. If they separate from a hospital employer now, and they have maybe a productivity contract where they're owed money on a production basis at the time of separation. So you've got this conjoining of issues when the doctor wants to leave. And I've seen that multiple times. I know y'all both have. What advice would you give doctors when they're facing situations like that, and as well as the new non-compete? Chris, I see everybody's looking wow, this would be a good question.
I think I would advise against, agreeing to a long-term retention bonus.
Right.
I think what'll be interesting is if anybody who has a long-term retention bonus right now and wants to challenge the legality of that, saying it's in effect it has the same effect as a non-compete provision, which our legislature has now radically changed. It'd be an interesting argument. It may be a bit of a stretch, but it has the same effect of restraining movement.
It does. And does the system want to challenge that? In other words, would that be something an employer, system, hospital want to take that step? Very interesting take on that.
That's good, Chris. I did not think about that, because it says the first two words in this statute say any provision in a contract or agreement which restrains. So it's not saying a non-compete provision. It's saying any provision which restrains from practicing medicine. So perfect example. These repayment things, I would 100% be comfortable arguing that if my client leaves in a certain window, let's say the window is 5 years, which does not jive with this, I would be very comfortable saying that is a provision that is restraining my client from practicing medicine, because if they leave, just like a non-compete, they're going to pay a penalty. They're going to have to pay back these funds plus interest.
What about the docs that have been like at the employer now for 5, 7, 10 years, and they call you up and say, "Can I get out of this now?" What's the answer?
Well, unfortunately, I think the way the statute's written,
it's effective as of the effective date
is January 1st, 2025. So they're going to have to wait.
Yeah, it says at the end of this act, it says for any agreements that are in existence as of the effective date, that 3 or 5 years starts on the effective date. So January 1 and the geographic provisions are the same thing. So for anyone in that situation, their clock is going to start January 1 of 25.
Got it. So what are the take-homes from this? So we got a specialist 5-year trigger, a primary care, which is broadly defined, Chris, for a 3-year.
Right.
Don't do long-term retentions. Make sure it's only 2 contiguous parishes, with your primary parish being stated where you work. And we don't start till January 2025. Is that sort of the and it's any provision? It doesn't have to simply stay not compete. Anything provision that could restrict, right? Wow.
Yep.
It's a big change.
Yes,
it's a big change. I think we will start to see, obviously, new agreements coming out next calendar year we're gonna have to make sure that they comply. Like Chris, us 3 are gonna have to make sure that it complies with this. But then I think we'll start to get the interesting phone calls in, what would that be, 2027?
Yeah,
probably,
for the
first batch of people that's going to be the first batch. Mm-hmm. So in the end of 25, end of 27.
So and I agree with everything you just said. What happens with the doctor that comes to you and says, "Hey, I started on January 1st, 2025, and now it's December 31st, 2027, and I just left." Can they enforce the non-compete? And I want to say, if you just would have stayed one more day, right?
Hopefully that doesn't happen to anyone. And look, this all a little bit hinges on what's going on the national FTC level with that.
We didn't even touch that today.
I know that's a whole other episode. I just wanted to briefly, talk about that. I mean, the FTC...
It's been challenged right now, correct?
It's been challenged in Texas, which Louisiana would fall under. I know it's been challenged in numerous states. We all listened to a webinar on that. And then the Supreme Court just came down with a pretty scathing opinion against these agencies.
The Chevron.
Yeah,
Chevron
such as the...
I mean, that's...
So I would
we haven't even touched that.
I would not be surprised if that completely goes away and all we're left with is our Louisiana version.
Well, I guess our legislators thought very highly of our physicians, so we'll see how it turns out, I guess.
All right.
Well, gentlemen, I thank you very much for this. I think this was a very interesting conversation, one that we need to continue. I mean, I think we've got a lot of topics, and I'm glad, Chris, to have you come back in the studio. It was so good to see you.
Yep, enjoyed it.
Thank you. And Rory, thank you very much. And for all those who are listening, thank you so much for listening to Chehardy Sherman's Health Law Talk. We'll see you next time. Have a good day.
Thanks for listening to this episode of Health Law Talk, presented by Chehardy Sherman Williams. Please be sure to subscribe to our channel, make sure to give us that 5-star rating, and share with your friends. Chehardy Sherman Williams is providing this podcast as a public service. This podcast is for educational purposes only. This podcast does not constitute legal advice, nor does this podcast establish an attorney-client relationship. Reference to any specific product or entity does not count as an endorsement or recommendation by Chehardy Sherman Williams. The views expressed by guests on the show are their own, and their appearance does not imply an endorsement of them or their entity that they represent. Remember, please consult an attorney for your specific legal issues.